Hearings are now held in person at Ben Franklin Place, 101 Centerpoint Drive. They also enable remote participation by video conferencing for our registered speakers. We are live streaming on YouTube, and the video will be archived and available for viewing by the public. My name is Fabien Poulin. I'll be chairing today's hearings, and you will address me by my name or as chair. And with me are my fellow panel members, George Barrett, Heather McLean, Julianne Wright. The procedure for the hearings today will be as follows. Listed on the agenda and appearing on screen from time to time are the applications we'll hear today. For the sake of efficiency, I may deal with agenda items in a different order. Panel members have reviewed the planning reports and any written submissions in support or in opposition to each of the applications. Today, we'll hear any oral submissions relating to the applications. As part of the statutory notification requirements, each applicant was required to post a sign on the property in question before the hearing. They also had to confirm in writing that they did so, or they'll need to swear or affirm an oath today that they've fulfilled the sign posting requirements. Otherwise, we may have to adjourn the application and postpone the hearing. I believe we have received all of the applications or declarations except for application relating to 140 Lusk. So I'll be administering the oath to that property's application. The panel may ask for a brief presentation of an application followed by questions for the applicant and city planning staff. We will then hear from members of the public who have registered to speak, may also have questions for them. Finally, the applicant, who has the burden of proof, will have the opportunity to make the final comments and reply. Please address your comments to the chair, starting with your name and spelling it if necessary, and your municipal address for the record. All presentations are limited to 5 minutes. Any exceptions will be at my discretion. At the end of the hearing, the panel will reserve all decisions, and so which means it won't be delivered today, but you will receive them within 10 days. In either case, and within 10 days, the Committee of Adjustment will send the official written decision and reasons for it to the parties and participants and anyone else who has requested a copy. Does anyone have any questions about the procedure today? No questions. We have several applications to hear, but we need to deal with some preliminary procedural matters. Are there any declarations of interest by any of the panel members on any of the panels we have today? No declarations of interest. We have two minutes to confirm, the minutes of July 4th and July 18th. First of all, are we going to approve the minutes of July 4th? All those in favor, please raise your hands. July 4th is approved. And then we have July 18th, the minutes of July 18th. Are they approved? Please raise your hands. July 18th is approved as well. Okay. All right, we'll now proceed with hearing the adjournment requests. So today we have two adjournment requests, one having to do with application concerning 1469 Portal Street. I'm looking for a J. McDonald. Are you online? Oh, no, you're here.
Good afternoon, Mr. Chair, members of committee. My name is Nadia DeSanti. I'm a practice lead at WSP Canada, Inc. And my colleague Jill McDonald is with us today. She's a project planner with WSP Inc. Our address is 2611 Queensview Drive, Unit 300. And with me is our client, Mr. Chris Simmons.
Good morning. Afternoon.
Yes, Chris Simmons, 1469 Portal Street.
Thank you. Now there's a request for an adjournment by planning. Are you in agreement with that request?
Yes, we are, Mr. Chair, and we have actually also requested an adjournment as there's some technical matters that we need more time to address. So we are seeking an adjournment sine die.
Great. So,
If I may also comment,
certainly.
Mr. Chair, I have been in consultation with neighborhood representatives. They've asked for some modifications to the design, and I am therefore putting a revised design together. And I want to make sure that that forms part of our application. And I will ensure that all the neighbors get that design in advance.
Okay, that's awesome. That's perfect. They'll be very happy with that. So will the rest of the rest of us. So to that end, I'd like to ask the panel if they would like to adjourn this this application, sine die. All those in favor, please raise your hands. Your application is adjourned. Thank you very much.
Thank you.
Next item up for adjournment. Sorry. Next application up for adjournment is application concerning 140 Lusk Street. Mr. Price, are you available? Is Mr. Price online?
Good afternoon, Mr. Chair. Can you hear me okay?
I can now. Yep. Thank you.
Good. So good morning, or I guess good afternoon, Mr. Chair. Rod Price on behalf of the owners of 140 Lusk Street.
Yep. I understand you'd like to have your application adjourned, sir.
That is correct. Through the site plan review process, there was a couple of other variances that were noted by staff. The architects were tweaking to see if they could play with the plan to avoid them, but it doesn't appear so. So we will be submitting a revised application in the next day or so to the committee.
Okay, so we'd like to adjourn this sine die. Are you in agreement with that, sir?
I guess that's committee's purview. I don't believe we would need more than a month to get the applications in. We have already discussed the variance with staff and whether they're supportable. So we're confident that the additions of these very minor additions to the application, if we can avoid going sine die, it'd be greatly appreciated.
Well, regretfully, we don't have any documents. I don't think that's the information I have. No documents to rely on. So we have to adjourn it sine die until we do get those documents. But we'll be able to post this is quick. Okay.
Okay.
So I'd like to ask the panel for approval of this application, sine die. All those in favor, please raise your hands. Perfect. Your application's adjourned. Thank you very much, sir.
Thank you, Mr. Chair. Have a great day.
Thank you. Now we'll proceed to the unopposed applications. And we have application number 2 having to do with 817 Roseview Avenue. Ms. DeSanti, are you available? Good morning again. Good afternoon.
Good afternoon.
So there's no opposition to your application. I'll just like to ask the panel if they've got any questions or comments. No? I'd like to ask the public if they have any questions or comments or would like to oppose this application. No opposition. Therefore, I'm going to ask the panel for approval of this application. All those in favor, please raise your hands. One thing I forgot to mention. Are you in agreement with all the conditions required?
Yes, our client has
And
agreed to those conditions.
Are you in favor of those conditions?
Yes.
Great. So again, I'll ask the panel to approve this application with all conditions. All those in favor? Again, approved. Thank you very much.
Thank you.
Ms. DeSanti. Next application up for that is unopposed is application concerning 2175 Alta Vista. Mr. Jalkotsky. Okay. I'm going to ask you how do you say your name because you're here often.
Good afternoon, Mr. Chair. Chris Yalkotsi.
Okay, thank you. So we note that your application is unopposed. Are there any persons in the public that would like to oppose this or would like to have some comments on this application? No opposition. Therefore, I'd like to ask the panel for approval of the application with all of the conditions. You're aware of the conditions, Mr. Yalkotsi?
Yes, Mr. Chair, I'm aware of the conditions and have confirmed the client is accepting all of the conditions.
Thank you very much. All those in favor with approval of this application, please raise your hands. Your application is approved, Mr. Yalkotsi.
Thank you, Mr. Chair.
You're welcome. Right. So the next application that is unopposed has to do with 2504 White Street. P. Warren, are you available? Good afternoon, Ms. Warren.
Good afternoon.
Good afternoon. Your application is also unopposed. And this application, let's find it right in here. Let's see. And it's an unopposed. We do have some conditions. Are you aware of those conditions?
Yes.
Do you agree with those conditions?
Yes.
Perfect. Thank you. I'd like to ask the panel for approval of this application. All those in favor? Your application is approved. Thank you
Great.
very much.
Thank you.
There was an amendment to the zoning, I think, on that one.
Was there in this one? I don't have, yes, I'm sorry. Ms. Warren, can I just have you come down one more time? Thanks, Ms. McLean. There was a correction to the zoning. Are you familiar with that?
There was a zoning amendment that was approved in May.
And so but on the document, when we sent out the documents, it was R1E box bracket 2873, and it was changed to R1E box bracket 2873 and R3Z 2874-8. Are you familiar with that? And you agree with that?
Let me just confirm. The zoning on the site is R1E box bracket 2873. And then that's where the existing detached dwelling is. And then the proposed portion of the lot to be severed is zoned R3Z box bracket 2874.
-H?
-H, yes.
Okay, perfect. Again, sorry for this back and forth, but I'd just like to ask the panel for approval of this application. All those in favor? Your application is approved. Thank you.
Thank you.
So moving on to application for 131 Winding Way. And I'm looking for R. LaBelle. R. LaBelle, are you remote?
Good afternoon, Mr. Chair, and fellow panel members. I'm Ray LaBelle with Hoban Architecture for 131 Winding Way.
Thank you very much. Mr. LaBelle, are you aware that this is unopposed, this application?
Yes,
And that variance A no longer required?
correct.
Okay. And okay. And are you aware of the standard condition, which is the subject to the location and size of the proposed construction be in accordance with the plans filed? Date
Yes.
stamp September 5. Are you agreeing with that too, sir?
Yes, Mr. Chair.
Thank you. Are there any objections to this application? We have no objections from the public. I'd like to ask the panel for approval of this application.
I just had a question.
Absolutely. Please, Ms. Wright.
I just had a question because this morning we received both a site plan as well as a landscape plan, which differed, and the landscape plan is still showing an overhang from the 30-meter Rideau Valley Conservation Authority line. Is that, I'm just curious why we received them this morning. Are they still relevant?
Sorry, yes, I apologize for the confusion. The landscape plan I included only as it referenced, and I made a note that it referenced only the driveway portion, and that the plans circulated last week. It did not include the, there's no more overhang as part of the revision, and that it was just there as supporting documentation as it was previously shared with the previous application documents.
Okay, that's fine.
Yeah.
I was just curious why we received them, but good, thank you.
Okay,
Thank
no
you.
problem.
Okay, so I'd like to ask the panel for approval of this application. All those in favor, please raise your hands. Your application is approved, sir. Thank you very much.
Thank you, Mr. Chair.
Next unopposed application is having to do with 48 Ryeburn. Mr. Bell, are you available? Mr. Bell, are you remote? Mr. Bell, are you available?
Yes,
Good
Hello,
morning.
Mr. Chair. Good afternoon, Mr. Chair. It's
Good
Mr. Bell
afternoon.
here.
Thank you very much. Mr. Bell, are you aware of any conditions? I just gotta find this. The conditions available are on this application?
In regard to Rito Valley and Hydro, what the paperwork that I received?
What I'm saying to you, sir, is that this application does not have any objections, so none of those agencies have raised any concerns.
Okay,
There is one condition that has been placed on this application, should it be approved. And that's that subject to the location and size of the proposed construction being in accordance with the plans filed, date stamped September 2nd, 2022. That's the condition. Based on those drawings, we are looking to approve this application.
okay, yep,
You in agreement with that?
I am, sir.
Great, thank you very much. Any comments or questions from the panel? No. I'd like to ask the panel for approval of this application with the one condition. All those in favor, please raise your hands. Mr. Bell, before you go, I just want to make sure that, and again, I apologize for going backwards a little bit. Just your application was missing the word meters after the word 3, after the number 3 in your application. So we just want to amend that so it just looks clean. So just to give you an idea of what it means, it doesn't change your setback meters. It says your side yard setback of 0.91 meters, whereas the bylaw requires a minimum side yard of 3. That's all it said. We just want to add the word metered after that.
Okay,
Okay. So again, all those in favor of this application? Sorry about that. Thank
no
you.
problem.
Your application's approved, sir.
Can I ask a question?
Sure.
Does that mean the variance is approved or just the application going through and I hear in 10 days, or does that mean I've got the variance?
You have the variance, sir.
Very good. Thank you very much. I appreciate that.
You'll receive the written confirmation that within 10 days or in 10 days.
That's terrific. Thank you. Everybody have a great afternoon.
Thank you.
Bye now.
Okay, so now we are moving on to the applications in order. This one is, we're going to deal with first is 304 Olmstead Street and 206 Levis Avenue. And I'd like to see Mr. Yalkotsi again. Good morning, afternoon again.
Good afternoon.
Good afternoon,
Mr.
sir.
Chair.
Your application, would you mind giving us a brief description of your application today?
Yes, if you can put up the presentation, please. Next slide, please. Just to give you a bit of a location in terms of, oh, back up one, please. There we are. Yeah. Location of the property, it's just south of Montreal Road, just east of the Vanier Parkway. It's in part of the neighborhood of Vanier. Next slide, please. Next slide, please. The application is to take 2 properties, do a lot line adjustment to add from part 1, 2, and 3, add 2 and 3 to parts 4 and 5 to permit a single family house on property on the part 1 section and 2 semi-detached facing Olmstead on parts 4, 2, and 6, and then also on 3 and 5. Next slide, please. This gives you a visualization from Google Earth of the proposed development. In front of you, you'll see the two semi-detached buildings, and behind that, you see the single-family property to the west. Next slide, please. This is the property being masked up with the adjacent church and seminary, what used to be seminary, but now used as office space. The single-family homes across the street, which are 1 story. The 2.5-story building to the north. Next slide, please. This gives you a street view looking north on Olmstead. Next slide, please. This gives you a street view looking east on Vanier. On Levi, excuse me, Levy. Next slide, please. These are the semi-detached buildings. They're a 3-story building. They each have a ground floor and basement 2-story ground apartment in the lower level, and a 2-story apartment on the 2nd and 3rd floor. In the front of the buildings, there is a space that can also be used as an office, because this zoning has a C suffix on it, which indicate the permission for some commercial. Olmstead's a bit of a wider street on this side. The garages are facing there, and they're combined together so that we really, with 2.6 meter wide garages in the space between, we only take up 5.5 meters of the streetscape. So it's about 33% of the overall frontage that faces onto Olmstead, trying to minimize that as much as possible. There are porches on the front of all of the buildings and on the 2nd floor balconies. Next slide, please. This gives you a little look at the shadowing. This is December shadows. So you can see from this that there are no shadow effects on adjacent properties, even in the wintertime. So you're looking at 9 a.m., 12 noon at the bottom middle, and at the upper right, you're looking at 4 p.m. Next slide, please. This is the site plan with the 4 buildings. We've located the single-family home as far away as possible from the property to the west, which is a heritage building. And where the bylaw permits a 0.6 meter and a 1.2 meter side yard, we've put the 1.2 meter side yard to the property to the west. And the rear yards fully comply, the front yards fully comply. Where we have variances, they deal with lot area, primarily because we're a corner lot, and there was a high desirability to have all four semi-detached dwellings be similar in terms of construction. It results in a circumstance where 3 of the properties have a minor variance for lot area. The other minor variance that we had initially been advised we needed, but we're being advised isn't necessary, has to do with the width of the zoning permits a lot at 6 meters width. Our lots are significantly wider than that, and on average, significantly wider than that. However, there was an argument that because it fell within the 6 meter zone, that a variance was required to permit a driveway, because the driveway is not permitted in a lot of 6 meters or less. It turns out, I guess, that got a little bit confused earlier on. As far as I understand it now, the planning staff believe that that variance isn't necessary. Next slide, please. What you can see here is tree planting. So the one tree that's being removed in the middle of the driveway is not in fantastic condition. It's also underneath a high voltage line. And so we've been able to locate 10 new trees. It's more than what's required under the bylaw, but we're happy to do it. My client is very happy to do it. Next slide, please. Next slide. And so we believe that the variances are minor in the sense that they don't create adverse impact in this neighborhood. Yes, they are 3-story buildings. The zoning does permit for apartment buildings. We believe that this is a much more appropriate form of building, has quite a high level of bedroom count in each of the units as well. So, and much more directed towards family, a family approach of a building. And so we believe that these, the variances are minor. They comply with the zoning from the perspective of semi-detached being a permitted use. Official plan, there being intensification, gentle intensification in this area. And finally, with the provincial plan, they're being developed within an already established urban area. In terms of the consent to sever, there being, it's not premature, it doesn't require a plan of subdivision, as it's already on existing services and there are no new public elements being created. Thank you, Mr. Chair.
One comment. It was an excellent presentation. Thank you. The units, are they 2 or 3 bedroom units planned for this, the 3-story buildings?
There's 3 bedroom. Oh, I'm trying to remember exactly. Just bear with me a split. Got the plans here. So the semi-detached are 2 bedroom units. The semi-detached are 2 bedroom units in the basement and first floor, and the second and third floor units are also 3 bedroom units. Sorry, and then the single family home actually has there's some on the ground floor. It in the basement, it has a 2 bedroom unit with a study space. Because of the bedroom count criteria, they can't have a 3rd bedroom because the number of bedrooms in the overall unit would push it into the rooming house category, right? And then it has 4 bedrooms on the 2nd floor and 2 bedrooms on the 3rd floor. So it's a 6 bedroom unit.
It's nice to see a diverse plan. Thank you.
You're welcome.
Mr. Yelkotzi, can you confirm that you are not requiring certain variances on each one of those applications? I believe there's a couple that you're not having on your list of items for this application.
Well, as I said, I've been advised by planning staff. I left them in the application because we got very specific advice and it went up quite high in the planning department back in September, October of last year. That said that we required this variance for driveway width. It's been subsequently, staff have indicated that they don't require this anymore. Now, from the senior planner that I was dealing with at the time, there seemed to be a discussion that there was going to be an omnibus change coming to the zoning bylaw, which would erase this sort of thing that happened where if you're on a lot that's in a zone that's 6 meters or less, then you wouldn't be permitted a driveway even if your lot width was greater than 6 meters. You see, this was the issue that came about. And it's a little bit distressing later on to find out that without having passed anything, the opinion of the city seems to have changed.
Okay, I'll move on to the city and ask their comments, and then we'll see what transpires after that. I'd like to ask planning staff to make some comments concerning this application.
Thank you, Mr. Chair. So I'm just looking back at my notes on this application, and so Mr. Yelkotski's referencing the provisions under section 139 of the zoning bylaw, which delineates specific driveway widths permitted based on lot size. So the provision under section table 139 3 specifies relates maximum permitted driveway width to minimum lot width or street frontage required. And so when we have the word required in the zoning bylaw, it's often tied to the subzone provisions. So when we're talking about minimum lot width required, that would be whatever the subzone requires for the zone. So in this case, a semi-detached dwelling in the R4UA subzone, the required width is 6 meters. In this case, it was determined that what required means in the case of table 139.3 is that you are required to have at least this much frontage or width before you can have this size driveway. So it's not actually tied to the subzone requirement for lot width. It's tied to whatever is actually provided on site. So in this case, all 4 lots for the semi-detached dwellings are 6 meters or greater in width. And so they're permitted to have a single lane driveway that's 2.6 meters wide.
Okay, so there are two variance requests, one on A0090. And that's to permit a single driveway. That's the variance A. Is that to be included in our discussions today?
No, none of the driveway variances are required. And actually, that sort of debate regarding the wording of required versus the intent of the bylaw is actually totally irrelevant anyway, because the lots are 6.8 meters wide. And so they fall into the category of greater than 6 meters to less than 7.5 meters. So they get they get a single driveway that's 2.6 meters wide.
Okay,
Period.
so that again, going on to the next property.
Yeah.
Variance E, is that one to be removed as well?
And that's also related to the drive. I'm just pulling up the notice. So if that's related to the driveway width, then no, none of the variances related to driveway width are required.
Okay, so there's 4 of them, right?
Yeah.
So
Yeah.
B is out as well as F. Is that correct?
So yes, anything related to the driveway width is not required. The only variances that are required are related to lot area.
Okay.
Mhm.
So Mr. Yalkotzi, sorry, the only 4 variances that we're looking at today are variance C, variance D, 3 variances and variance G. Is that correct? Perfect. Okay. So now I'd like to ask planning, if you got anything else to talk about?
Thank you, Mr. Chair. No, I don't have anything else to add.
Okay, thanks. I'd now like to ask members of the public if they got any comments to make about this application. Yes, sir, come on down. Please take a seat. Please state your name and the spelling it if necessary, sir.
Yeah, my name is Matthew Hadwin, Matthew Hadwen, 200 Levy Avenue. What I'd like to say is, first of all, that I'm a very concerned community member. I'm a believer in Jesus Christ. I sincerely hope that the Committee of Adjustment is also as committed as the citizens of Annie are to the poor. This application has already resulted in the displacement of two families. Before the variance was even applied for, they were told to leave. The main point I'd like to make, yes, I know, it's okay.
Okay.
The next thing, really, the issue I'd like to first of all point out is that there has been a submission by the Banyan Community Association, which is opposed to this application. And they had a meeting last night to indicate that they, I don't know whether they've sent a letter. There's also the councillor, Stephanie LaPlante, is also expressing her opposition to this application. So those reasons can be contained in their submissions. Myself, and as a community member, I'd like to express my concern as to whether the application is viable. We have many lots in Vanier that are already have been cleared, and sometimes you wonder whether people are just preparing it to flip the property. And these are the sort of concerns that are additional, really only just additional to what the Vanier Community Association has expressed. Finally, I'd like to say, and this is probably the most important point, is that the application, there's 206 Levis, there's substantial heritage interest that had not been really examined previously. There needs to be some time to establish that heritage interest. I presented it to the Committee of Adjustment, and it's based on the person who lived there and his wife, who were active members of Assumption Church in the back. So there's community interest based on the people who lived at that property. The thing that, in summary, I'd like to say is for a variance to involve what has not been mentioned already, the demolition of two houses on Olmstead and Levis is from a community standpoint quite a remarkable thing, that a small sign on is actually going to result in the demolition of two important houses that the community is used to seeing, and especially one that really needs to be examined for heritage interests. So that's all I'd have to say. Thank you.
Thank you, sir. Does the panel have any questions for the public? Mr. Hyden? No? Ms. Wright? No. Mr. Barrett? Ms. McLean? No? No further questions. Thank you very much, sir. Okay, so now I'd like to ask the applicant if he's got any final words.
Yes, Mr. Chair, just to address the community's concerns, in my presentation, I quoted on the sort of comments that the project feels squished in. And again, with regards to the driveways, we've done the best that we possibly can to both comply with the zoning bylaw in terms of minimum lot areas, lot width. So lot width is greater, lot areas is somewhat smaller, but also the design of the project is such that the backyards of the, what I would say, squished in homes are adjacent to the single family home. So they actually have no, and that's why I say a variance is minor in the sense that they really have no adverse impact on neighboring properties. And we've tried to minimize the impact on the neighboring properties to the maximum extent possible. And again, with regards to the community's concerns regarding the driveway, with the width of the boulevard there, one of the benefits is that a car can park in the garage and a car can park in front of the garage, and yet we still have something like out of the 30 meters, we have 18 meters of unencumbered curb width that will, if in future desired, have permit parking along the side of the street as well. So from that perspective, I believe that the community's concerns have been addressed. Thank you, Mr. Chair.
Thank you very much. The committee will reserve judgment on this application. You'll be able to receive the written judgment within 10 days or in 10 days.
Thank you, Mr. Chair. Thank you, committee.
You're welcome. Okay, the next, and I believe last application we'll be here today has to do with 50 Rebecca Crescent. Ms. Warren, are you available? Morning, again, good afternoon.
Good afternoon.
Please give us a brief description of your application today.
Okay, I do have a presentation prepared if you'd like me to go through that, or just to.
Go ahead.
Sure, I'll just wait for it to be pulled up here. Perfect, next slide, please. The subject site is located in the Rothwell Heights Beacon Hill North neighborhood of the city of Ottawa. The site has a lot area of 1,935.9 square meters with approximately 40 meters of frontage on Rebecca Crescent and 48 meters of frontage on Massey Lane. Next slide, please. The owner of the subject site is proposing to sever the existing lot in half into two parcels. The existing dwelling is proposed to be retained while the severed portion is intended to accommodate a future residential dwelling. Through the creation of the two lots, minor variance applications are required to seek relief from the minimum required lot width for each lot. The minor variances being sought request a reduction in the lot width for the retained parcel of 25.28 meters, where 30 meters is required, and a reduction in the lot width for the severed parcel of 23.03 meters where 30 meters is required. Next slide, please. No new development is proposed as part of the consent and minor variance applications. However, a potential building footprint applying all of the required zoning provisions has been provided and is shown on the screen. I'd like to note the importance of tree retention, and as shown on the concept plan, the potential building footprint has been notched out to try to protect the trees on the site. The existing dwelling will remain on the site. However, the existing sheds, carport, and garage will be removed to ensure zoning compliance. Next slide, please. It is our professional opinion that a plan of subdivision is not required for the orderly development of the lands and that the proposal meets the criteria for lot division established in the Planning Act. In the interest of time, I won't go over all of these criteria as it's outlined in our planning rationale. Next slide, please. It's our opinion that the proposed minor variances maintain the general intent and purpose of the official plan. The subject property is designated as neighborhood within the outer urban transect of the official plan, and the neighborhood policies envision a gradual evolution of neighborhoods towards a denser urban fabric. The proposed minor variance contributes to this gradual evolution through the creation of one new lot for residential purposes. Next slide, please. It is our opinion that the proposed minor variances maintain the general intent and purpose of the zoning bylaw. The proposed lots will meet all other zoning provisions related to the severed and the retained lots within the R1AA zone. The lots will meet the lot area requirement, which indicates that adequate space is available and being provided to accommodate residential uses that are permitted within the zone. As previously demonstrated, a future residential dwelling can be accommodated on the severed lot while meeting all other zoning provisions. Next slide, please. The proposed variances are considered to be minor in nature. The Planning Act test is generally understood to involve the consideration of negative impacts from the proposed variances. The variances seek a reduction in lot width from 30 meters to 23.03 meters and 25.28 meters, which are consistent with a significant number of the surrounding area lots as shown in orange on the screen. As a result, the narrower lots, which are not likely to be detected given the surrounding lot fabric, are not anticipated to generate negative impacts on the surrounding community. Next slide, please. The proposed variances are desirable and appropriate for the development and use of the property. One new lot is being created within a fully serviced neighborhood on an existing lot that is larger than the required minimum lot area. The resultant lots will be consistent in size and shape with lots in the community, while also allowing for the retention of an existing dwelling and the provision of a future dwelling that can comfortably accommodate all required zoning provisions. The resultant lots represent the gentlest form of intensification, which is the direction of the official plan, as well as provincial policy and the provincial policy statement. Next slide, please. With that concludes our presentation. It is our professional opinion that the consent application is appropriate for the subject property and that the proposed minor variances and the consent application constitute good planning and are in the public interest. I would like to note that we did review the conditions and we do have some concerns with condition 6, but we're happy to loop back to that.
Okay. If you want to outline your concerns on condition 6, we'd like to hear them.
Thank you, Mr. Chair. Brian Casagrande. I'm a partner with Votan Consultants. I've been working with Patricia on this file from the beginning, really. So that condition was received late last week, and the concern I have with it is, I mean, first and foremost, I can tell you that Votan is always trying to plan to preserve, valuable trees on development sites. So it's a value that we hold. The owner also shares that value, and that's why that concept plan actually shows a notch, around that tree. But at the end of the day, the wording of the condition is concerning to me. It's concerning on a couple of fronts. The one, I think it's B, as I understand it, is like a carte blanche condition that says that you're to basically accept the possibility that you're gonna have to move your house or your future building, driveway, anywhere on the property that's necessary in the interest of tree preservation. And to me, that's worded in a very aggressive way, and it's overreach. If it was moderated in any way, that there was a sense of reasonableness to it, especially given the fact that the as of right opportunity in this property would be to have expanded it and build 3 units as of right as it is today. And that would just go through a building permit process. It just doesn't seem reasonable to me. The second concern that we're experiencing regularly is the notion of actually getting an agreement back from the city on a timely basis. We've seen situations where consents can't fulfill the condition in time or have to go back to the committee. And we experience this in all kinds of development applications. So, you know, my personal opinion on it is that I'd like to see the condition reworded so that it actually focuses just on the city-owned trees in the right-of-way. Firstly. Secondly, that it actually has a time constraint to it, that if the city doesn't provide the agreement within a reasonable amount of time, I would say 3 months, that the condition is not applicable. And that thirdly, there's no situation where the city could ask an applicant to actually seek variances again, if in return to this committee, to try and protect a tree. And that's certainly a possibility as it's currently structured. So if it could be reworded that those 3 elements were taken care of, then I think our client would embrace it and understand it. All that to say that, you know, he's willing to work with the city. This plan was revised to align with city concerns from its original configuration. You know, that's his nature, that's his attitude, but it's just being bound in this way that's of concern. And the last thing I'll say is the only tree that's really likely to be impacted that's not a city-owned tree is actually, and if we can go to the last slide in our presentation, it's part of the report that was submitted. And it actually calls it out to be in fair condition. And they're concerned that it may not actually survive construction. And so my personal view on it is if all the other trees can be preserved and protected reasonably well, at the end of the day, you know, we may end up losing this tree, but we could plant a better one or a new one in the backyard, which I think would be a better end result. So that's what I'd like to leave with the committee for consideration.
2 things. First thing, which tree is it?
That one there in the middle, it's
Between the 2 houses?
Yes.
Okay. And the second thing is, do you have the wording of your suggested change to that condition?
So my wording would be that both A and B are worded to apply to city-owned trees, that the time limit is on the city of 3 months to provide it, and that no variances are needed or would be forced upon the applicant to address the condition. Now I can provide that in writing as soon as I get back to the office if it helps the committee.
It will.
Okay.
Yeah. Okay. Thank you very much. I'd like to ask the panel if they have any questions for the applicant. Mr. Barrett. No, he's right? No, I don't. Ms. McLean. Okay. Now I would like to ask planning for their comments, please.
Thank you, Mr. Chair. So this morning we received an email from the agent asking to amend condition 6 as they've described. I discussed their request with our infill forester, Nancy Young, who I'll invite to speak after me. So the request regarding amending the condition 6B. So condition 6B addresses all of the protected trees on the property, not just the city-owned tree on tree number 7 that's in the right-of-way. So what condition or 6B is a standard condition that we impose on applications where there are protected trees anywhere on the lot. And so the intent behind that is to ensure that that any protected tree outside of the as of right building footprint is accounted for when it comes to grading and servicing and things like retaining walls and driveways. So there are additional protected trees on the property. One of them is included in the as of right buildable area. So although their tree information report shows that the trees plan for retention and the building footprint goes around it, we can't actually hold them to that. We can't tie any of these variances to the plans because they don't have any plans submitted yet for new development. So it's quite possible that plans could change and that one protected tree on the private property will be removed, which is it's unfortunate, but it's within the as of right buildable area. And so we can't withhold the tree removal permit for those reasons. So as I said, the security is in place to or pardon me, not the security. The second condition 6B is in place to address the other protected trees that are on the site. With respect to the development agreement, that also has to do with the security for tree 7. Development agreements are reviewed by city legal staff in the order, and they're prioritized based on lapse date. So a consent application has a 2-year lapse period. So to condition an expedited preparation of a development agreement at the expense of other people who are already in the queue for development agreement would not be appropriate in staff's opinion. So there is a 2-year period to clear all the conditions. So if we're waiting months for other conditions to be cleared, it's not appropriate to expedite one aspect of the consent application, like one of the conditions. So I don't think we could compel legal services to do that anyway. And certainly in my experience, I've never seen an instance where a development agreement is held up solely because legal services just didn't get to it on time, because we would be held responsible for the lapse in that consent. So typically, if there's a delay in preparing a development agreement, it's because all the required plans and studies have not been provided. So in addition to legal services prioritizing development agreements based on lapse date, if there's an application that requires a development agreement where the lapse date is approaching, but they don't have the approved plans and studies to prepare the agreement, the city is just going to, I guess, skip over that one and go to the next one that's in the queue. So this is a pretty straightforward application. There are some standard conditions related to grading and servicing, but those aren't related to any other development agreement. So again, I have no concerns that the development agreement will be prepared far before the lapse date of the condition. And I'll reiterate that I don't think it's appropriate to condition an expedition of that agreement. I think it would set a precedent for other applications. Although I recognize that the committee is not a precedent-setting body, I don't think there's sufficient reason why we should do that. And as I said, the condition related to all the other protected trees on the property, it's a standard condition. And certainly you don't apply for a variance from a tree. That's not a thing. So if there is a tree within the as of right buildable area, the applicant is permitted to apply for a tree removal permit. The conditions is there to address the other protected trees on the property.
Thank you.
I can turn it over to Nancy Young. She's the infill forester, and she can add to that.
Good afternoon, Ms. Young.
Good afternoon. Thanks, Cass. I think Cass really covered it. We did have this conversation this morning, and I do not support altering the condition as written. The intent of that 6B condition really is to protect other trees on site, and it's all within reason. So as Cass said, we cannot require additional minor variances for this. That's not something we do. This is a standard condition that we use on all kinds of files. So really all it is it's forcing a conversation. I guess once plans are developed, then we have that conversation with the developer. And if there are concerns about any trees at that time, then it means we can work them out. So that's the intent of that one. I can't really speak to the development agreement. I think Cass did that, but if you have any other further questions about this condition, I'm happy to answer them.
Okay, thank you very much. I'd like to ask the panel for any questions they have for the city's planning department. Ms. Wright?
I don't.
Mr. Barrett? Ms. McLean?
Thank you, Mr. Chair. Either to Ms. Young or the city planner, we're not dealing with development of the vacant parcel of land today. We're just being asked to create the development. So are there not city tree bylaws in place that will be enforce tree protection at the time that a development application comes forward?
Yep, I can answer that. Yes, the tree bylaw is in place and will be enforced when this comes to building permit. The condition that we've imposed is a standard condition that we apply to all severances, really, that even those that don't have any concept plans or anything at all. It's just to guide the design process saying that there are protected trees on this site and your plans should account for them. That's essentially it. It's not holding anyone to, additional variances or anything like that. So there will be a bylaw there is a bylaw in place, but we do recommend leaving this condition in just to help guide the process.
Thank you for that. I don't think I will be supporting that condition. And that the bylaw will be enforced when development comes forward. The other question I have for planning is the length of a development agreement. So am I hearing that there's a queue to meet the condition, and then it could hold up a severance or the completion of a severance, or?
So thank you, Mr. Chair. So I'll just answer your previous or add on to your previous question as well. The development agreement is also going to contain the details related to the security for tree 7. So while there is a tree protection bylaw in place that will that outlines which trees are protected and subject to tree removal permits, the actual security related to tree number 7 and the details of that security get captured in the development agreement. And that is registered on title. So any new development on that property will always be subject to the agreement if the property is severed in advance of the 2 years that the security is held. So in terms of the second question, which is if I understand correctly, you're asking that, sorry, go ahead and clarify your question.
I guess it's just the time we're hearing that there's a timing problem or that.
No, so all the conditions of any consent application have a 2-year lapse period. So the applicant is required to fulfill those conditions within a 2-year time frame. So they're not obligated to rush and get everything done and prepared on all the plans and studies that are required. In this case, some of the conditions include demolition of a portion of the building. So there's going to be building permit applications, et cetera. So the likelihood of all the other conditions being fulfilled within 3 months, which is the timeline proposed by the applicant for when the development agreement condition should lapse. I don't think that's a realistic timeline. So before the 2-year lapse period is up, City Legal Services needs to have drafted that development agreement to register on title. And as far as I know, it's never been the case where the city has not fulfilled their half of that condition, like to prepare the development agreement prior to a consent lapse date. So there's no fear on our end that the city is going to forget about this application and just let that condition or let the condition period lapse and prevent the severance from being registered. So at Legal Services, there is a queue of other consent applications ahead of this one, and there's site plan control applications, et cetera. Any sort of Planning Act application that requires a development agreement all get reviewed by Legal Services. And there are many, many, many in the queue to be reviewed and prepared and registered. So my comment to the applicant requesting that the development agreement be prepared within 3 months, no other application has the benefit of that sort of timeline. So to impose that condition with a 3-month timeline for a Legal Services staff, it may not even be realistic for Legal Services to drop all these other agreements, some with pending lapse periods, to prepare this development agreement.
But if someone wanted to complete their consent within 6 months, it would get done. This type of a condition wouldn't hold up a completion of a severance application.
So if someone wanted to get their conditions, so if someone wanted to have all their plans and studies and all the conditions, all the things that they needed on their end to give to the city, so that the city could review and determine whether or not the condition has been satisfied. Certainly an applicant could get those things done in 6 months if they had the resources to do so. Whether Legal Services would then be able to review the development agreement and register it, I can't say. I don't know what their workload is like. What I can say is that they're not going to let the lapse date arrive without having done the development agreement. That would, we just couldn't be responsible for lapsing a consent application simply because we didn't get it done within the 2-year period. But there's nothing There's nothing in the Planning Act that compels expedition of a consent application if other conditions are fulfilled early, for example. Does that provide some clarity?
I just wouldn't want to impose a condition that prevents, that makes someone have to wait 2 years when they want to complete a severance and do development, because there is a move development forward.
Yeah.
And have it held because we're looking at a 2-year versus.
Yeah,
That's where I'm coming from.
Yeah, so I understand that. So again, I can't speak to the workload of legal services, but I think, like, I guess to put it another way, if every consent application had imposed that required a development agreement, had a timeline imposed on legal services to complete the development agreement, I think I just don't think legal services could get it done. So while they do prioritize based on the lapse date of a consent application, as I said prior, if an application with an impending lapse date has not fulfilled all the conditions, legal can't actually draft a development agreement if one's required. So they'll just move on to the next one in the queue. So it's not always that, you know, they're not going to see their development agreement registered until, September 15th, 2025. It'll likely happen earlier, but we have to account for all the other applications where the conditions are already done and in the queue waiting for their development agreements. So, and it could very well be that the other conditions aren't satisfied by the applicant within the next 3 months. I can't speak to what work needs to be done on their part to do so, but I don't think that it's appropriate to impose a timeline on another department when we can't. Yeah.
Good, okay. I think, Mr. Casagrande, if you should try and take into consideration planning department's request and discussion about timelines. When you provide us with that written change to the condition, we'll consider it.
Understood.
Okay, but it's important to take their comments into consideration.
I guess just the last thing I wanted to say, Mr. Chair, is, I just think that the responses you're hearing are indicative of the reason why I don't think you should have legal agreements associated with what I'm going to call the more simple severances, because it's already a litigiously oriented process. And these types of applications by their nature should be the ones that are expeditious. We have a housing crisis. And to me, this is just wrong on so many levels, but, and I'll give you my view and I'll give you my suggestions, and hopefully the committee is sympathetic to that.
Thank you, sir. I'd like to ask the public if they've got any comments to make about this application or questions. Yes, is that you, Mr. Ho? Come on down. Please state your name and your address for tribunal.
Benoit Ho, 4805 Massey Lane. Do you need me to spell it?
No, I think that's good.
Okay.
Yeah.
Well, I had a nice speech prepared, but I'm going to start a little differently now than after Mr. Casagrande said this is just wrong, and I'm here to say this is just wrong too.
You have five minutes. Sir.
Yes. Okay. The first time I was going to come, I had my legal services and they were supposed to do the talking. As you can see today, I don't have my legal services today. I've put in a 15-page submission of why we don't agree with what they've done. And you'll see our legal arguments for why it shouldn't be approved. There's a restrictive covenant. The minor variances are neither minor nor are they in line with the official plan. So you can read our written submissions on that. But that's not why I'm here today without my legal counsel. I'm here today without my legal counsel because this is outrageous. What they have done is completely outrageous. All right, I'm going to go back to January and I'm going to talk about it. You can read it in my submission. But back in January, the first application that they provided, they lied under oath about their consultation.
No, sir, please don't use that kind of language.
Well,
here, okay?
excuse me, but
you can tell them they're misleading you, but please don't use the word language lie.
I
respect these other people.
Very well. I provided you with email from Mr. Belmar to Mr. Yalkotsi. I didn't know his name was Yalkotsi. I thought it was Yalkotski, but I provided you the email chain. where Mr. Yalkowski claimed, and he swore under oath in the application form, that he consulted with the ward councillor, the local community association, and all the neighbors. And we called him out on it. Tim Tierney sent an email to Mr. Belmar saying that is untrue. He was never consulted. And Mr. Yalkowski then admitted that's true. He didn't consult. Okay. So I'm not going to call it a lie. I'm just going to say it was sworn under oath and it wasn't true. Now we come to this application, and I look through this application, you look at the consent, and it says there are no restrictive covenants on the land. Signed under oath by Mrs. Warren. My legal counsel checked on Friday again. There are legal covenants on the land that prohibit a second dwelling being built on this land. Okay, so I'm not calling it a lie. I'm just saying what is in the application form is not true. And so false information has been submitted to this committee the first time and the second time on the application forms. Now, if I didn't look into this, I don't think anybody would, because I don't think your staff does it. I don't think the city's planning staff does it. So the question is, you are just then relying on the applicants to tell the truth. And the question is, what do you do when they don't? If there is something false in an application form, what do? Do you just say, well, too bad, right? So then anybody can just come here, submit documents, and if it's not true, well, if there's no consequences, what incentive do they have to tell the truth, right? So in this case, and I'm going to try to be very careful in my wording, in my opinion, there have been several other instances of bad faith. I believe they've tried to subvert the notice process. I believe that in the first time Mr. Yalkowski was answering questions, he was very misleading and told things that were not necessarily the truth. And finally, just last week, they completely changed their proposal to essentially, because what's happened now is there's not a single document available for public review that is up to date. I went on your website on the weekend and I'm looking, and every single document is completely out of date. So how is the public supposed to come in and say, let us give you our comments on what's there when all of the documents are no longer relevant? It just doesn't make any sense. And I don't know how much time I have left. Okay.
1 minute.
So, all right. There's a crisis in the city and in the province. We get it. We need more houses. There's not enough supply, and everybody agrees to that. But you know what? There's a second crisis going on in the province today. You can read it in the front page of the paper. The Minister of Housing just resigned yesterday. There's a crisis of confidence regarding the process involved in the approval of intensification projects. People are concerned that developers and decision makers are acting in bad faith and against the public interest and only for their own benefit. And I've put some quotes from the Auditor General, Bonnie Lysyk, in my paper, and I only have a minute left over this, so I'm not going to get into that. But the point is, the process matters. And I'm asking you today to uphold your responsibility to safeguard those processes by denying this application because of the bad faith actions of the applicant and of their agents. I get it, there's a housing crisis, okay? We need more houses. But let's be clear, this is about building one house sometime in the future. Not sure when it'll be, but it's probably going to be a couple of years. So that's not going to have a significant impact on our housing crisis. What is going to have an impact is that if you deny this application, it's going to send a message to developers that you can't provide false information to this committee. You can't mislead the committee, and you can't submit documentation that are full of errors, omissions, and misrepresentations. And I've detailed them all in my 15-page submission. So if you want to go through them, I invite you to do that. So that's what I have to say.
Thank you very much, Mr. Ho. I'd like to ask the panel if you've got any questions for Mr. Ho. Mr. Barrett?
Mr. Ho, I believe there was public consultation. It may not have included all members of the public, but
may I clarify?
Yes.
When you say public consultation, when are you talking about public consultation?
When?
Yes, when?
When the process was first started.
Well, the reason I'm asking you to clarify when is because when I'm saying that false information was provided, we can go back and take a look that the original application form signed by Mr. Yalkotsky that said there was consultation with the counselor, the community association, and the neighbors was sworn before a commissioner vote on January 10th, 2023, okay? Now, I have spoken to Mr. Tierney. I've spoken to Jane Bremer, who's the Rothwell Heights Property Association president, and I have spoken to every single neighbor within the 60-meter notice area. And I have with me here, in case you want to look at it, from every neighbor, I have a statement that says they were never consulted before that statement was sworn. And as I said, I've attached for you in an email chain, an email from Councillor Tim Tierney to Mr. Belmar about that, where Mr. Tierney, what's the word? Contests the fact that he was consulted and says he was not in fact consulted. So I just want to make sure we're clear. When you say there was consultation, which consultation are you talking about? Because I'm saying in that original document that was sworn by the previous agent of the applicant, when they said there was consultation, it was sworn January 10th, and there had never been any consultation with anyone. But if you're telling me you want to talk about consultation at another period, let's talk about that.
Can I ask the applicant, did you make any efforts to discuss things with the public?
Yes, I'm happy to respond to this. So Foten, as you know, is brought in the second application, not the first. We were consulted at the end of the first, and we gave our advice on reconfiguring actually the application. Mr. Jalkowski's here, and he could speak to the whole notion of the previous application that, you know, he acknowledged the error. Foten does not acknowledge any error. We made the application out to the best of our knowledge. Now, if there's some sort of restricted covenant on the property, we weren't aware of it, and we're still not aware of it, and we'd love to see it. And I'd actually ask why someone wouldn't provide that earlier than now, if in fact it has merit. But beyond that, we've taken every initiative to try and reach out to the community association last week, which we did, and the local counselor's office, which we did. And those are the only two bodies that we actually have contact information for. And we've provided our information to the committee on a timely basis in terms of all of the revisions. So as far as I know, we've followed all of the necessary rules. In our actual application, we checked no to the public consultation component because at that point in time, we hadn't.
You did sign a sign posting declaration that the sign posting is up.
Yes.
In accordance with the rules and regulations. So the sign was clearly posted. Everybody that drove past that property could see it. They pick up the phone and call whomever they needed to call at that time.
100%, Mr. Chair.
Any other comments? That's right. So we don't have any other.
Mr. Chair, your microphone is off.
Oh, sorry. Thank you. So there are no further comments. We will be reserving judgment today, and your application will be heard after this meeting, and we'll make a decision, and you will be notified of that decision in 10 days. Thank you all very much.
Thank you.
Okay. So I think that ends today's applications and today's hearing. Thank you all very much for your help. Appreciate it.